Yes, where are we at, please?
Good morning, Your Honour. Well, we apologise if we're here today and we don't want to waste the court's time. As Your Honour is aware, this is an action for a specific performance by the claimant, and the claimant was seeking an order ordering the defendant to comply with its obligation under the management agreement and hand over the body corporate property of the claimant to the claimant or to Associa property management, the new manager of the body corporate. The claimant was also seeking a declaration that the appointment of Associa as manager was valid and that the notice of the annual general meeting issued by the defendant was invalid. In light of the recent development in the past few weeks and the past few days, it appears that most of the orders are now moot. The defendant has recently handed over the body corporate property to Associa and has acknowledged that Associa is the new manager and that that data and information in the My Strata system is in fact the property of the retail body corporate. Primarily, there are two outstanding issues. The first is the issue of cost, and the second one is that the claimant is seeking an order from the court ordering the defendant to certify that it does not retain any documentation, data or information belonging to the claimant. If I may address the issue of cost first.
Just hang on a second. We actually have the appearances as Bismarck Talbano, is it?
Yes.
Yes, and sorry for the
Council's name is Gamble.
Gamble. Thank you, Mr. Gamble. Yes. Well, let me just inquire of Mr. Gamble. Mr. Gamble, what's your position in relation to those two matters? I should may I withdraw that? I'll go back to Ms. Montalbano. What do you say should happen about costs?
About cost, Your Honour, our position is that cost of this action should be awarded to the claimant because the reason we're here today...
Well, don't worry about the reason. So you say two things. One, you want an order for costs of the proceedings.
Yes.
And two, you want an order that the defendant certified that it doesn't have any more of the, what I'll call the relevant property.
Precisely, Your Honour,
right.
Yes.
Now, back to Mr. Gamble then. Mr. Gamble, what's your position on those two matters?
Sir, in respect of costs, our position is that costs should lie where they fall, and we'll address that in due course. In respect of the certification, that is, in my submission, slightly different to what was initially...
I just want to know what your position is.
Yes, sir. In respect, our position is that everything has been handed back and all property has been returned.
Well, I take it you would have no difficulty in certifying that. If they want a letter certifying it?
Or undertaken from our clients.
Well, they have said they want to certify. Presumably a certify means a letter saying I certify. Do you have any difficulty with that?
No, sir.
Well, that takes care of the second matter, doesn't it, Ms. Montalbano?
Thank you, Your Honour.
All right. Well, the court, I rather doubt that that's a matter that the court would order, but it doesn't matter because that's a convenient way of making sure that part of the dispute is resolved between the parties. Can I take it, Mr. Gamble, that certification will be given?
Well, sir, those are my instructions, yes.
Yes. It would be very good if, I don't know if you've got enough people helping you, if people behind each of you put their heads together, worked out the letter that's required, and so we know exactly whether everyone's happy about it before we part today.
Yes, sir.
So, yeah, are there enough of you to do that or not? Doesn't look like it, does it?
No, sir, it doesn't. Not, but as Your Honour has indicated, it would be good if we could get that done promptly, and maybe maybe if we could move to the question of costs,
Yes.
while we attempt to identify how quickly we can get to
Just how you can get
certification.
that letter worked out,
Yeah.
that would be good. All right, well, let's move to the question of costs. Now, back to you, Ms. Montalbano. You want that order for costs, and Mr. Gamble says no, he doesn't. He doesn't think that's the right order. He wants a different order. Now, how am I going to resolve that? Do I have to decide the whole case in order to resolve that?
I suggest, Your Honour, if I may summarise briefly the facts which we believe will demonstrate why the claimant should be awarded the cost of this case.
Which are, I take it that they are essentially that, as you indicated earlier, that since you started the proceedings, the defendant has effectively given you everything.
Yes,
Is that the essence of it? We'll come to the detail, no doubt.
Yes, that's correct, Your Honour. But even prior to that, the management agreement with the defendant expired in June 2015. On the 1st of June 2015, Asteco was appointed as a new manager of the retail body corporate.
But at this point you are going into the substantive facts of the original dispute, aren't you?
Yes, Your Honour.
So that comes back to my question. If I were to listen to what you said in that respect, then there was a defence to that, saying no, that despite all that, we didn't have to hand it over, and I would have to decide that, which is not really a very good thing to do at this stage, is it?
Yes, Your Honour. We will be happy to make cost submissions in writing.
No, we're doing it now. This is going to be put to bed today. So why don't you ignore the original dispute and tell me why you say, apart from whether or not you are right or wrong in the original dispute, there should be the costs order you seek. You will no doubt tell me some facts about what occurred. I don't know if I have proper evidence of that, but if you tell me those facts, they may well not be in dispute. Mr. Gamble can agree to them, and we can decide what their effect may be.
Yes, Your Honour. Well, even without going through all the facts of the dispute, the defendant has refused to hand over the document of the claimant for months. And even when it started handing over the documents, it was already in December 2015, and this happened after the case was filed and after 3 orders of the Register of Real Property acknowledging that Asteco was the new manager of the retail body corporate. And even after the defendant started handing over the documentation in mid-December, and then a second package was handed over at the end of December, and then in January, it still refused to provide access to the primary data into the MyStrata system. And the way this, and it has refused to provide an NOC, which MyStrata was requesting, which in the ordinary course of business, how I understand this works, when there is a change in the manager from the old manager to the new manager, an NOC, an objection letter, has to be provided to MyStrata in order for MyStrata to transfer the primary data from the old manager to the new manager. And the defendant has refused to do so. And the reason why now this issue has been solved is only because the claimant had to seek the intervention of MyStrata and had to negotiate with MyStrata the transfer. And I understand that this was the first time this has happened to MyStrata, that the old manager didn't want to provide the NOC. So if we put all these facts together, the defendant, as for months, refused to comply, has ignored previous orders of the Register of Real Property, and has refused to cooperate, and the issue was finally solved, not because the defendants decided to cooperate, but only because the claimant was able to obtain what it was its right to obtain since the very beginning.
Right. Well, let me just run through those facts with Mr. Gamble. Mr. Gamble, as I understand, first of all, I may not have a correct understanding of what's involved, but it certainly involves some hard copy material and apparently some material on a database controlled by Maestrata. Is that
That's
a
my
broad understanding?
My understanding of the position, sir. In respect of the information, there are broader issues, but in respect of the information,
right. Now, what is said is that after the proceeding, the proceedings were started because the defendant refused to hand over the hard material or do what was necessary to give the claimant access to the database, that in December and January, that is fairly recently, the defendant did hand over the hard copy material, and that the claimant was able, by other means, to get access to the database material. Those are the facts that are actually said to have occurred. Do you agree that those were the facts?
Not. My understanding is slightly different, sir, and also I think there are other relevant considerations that I think come into.
Okay, well, we'll come to the other matters, but let's just see how much agreement there can be on those facts.
My understanding is that there is an element of dispute as to what extent but sir, if I can just step back, and I'm sure Your Honour has picked this up, but the difficulty in this case is that there are several different body corporates responsible for one building. Associa was the manager for the entire building. The retail body corporate is responsible for one part of the building. The difficulties that have arisen in this case have arisen because there's what I've described as a latent tension between the ability to appoint for the whole building and the ability to appoint for part of it. As I understand it, specific instances, there are issues as to what extent items the claimant is entitled to possession of certain things, and to what extent the principal body corporate and its manager are entitled to possession of certain things. I think that
those issues would not seem to be material if, in fact, the defendant has handed material over to the claimant, then it must be that that's the claimant's material, otherwise it wouldn't have been handed over.
Yes, sir. Although, as Your Honour is probably aware, there was the supervening order of the registrar, which, in my submission, effectively decided or led to the position we're at today, and which was an administrative act. It wasn't necessarily a legal determination. If I may, in respect of the material that has been handed over, and that order was made in December, and the process of handing over started immediately after that. And then, while there were some, I think there's some dispute as to who advised who as to when certain material was available for collection and that sort of thing. I think that process from our side took place as quickly as it could take place. In respect of the soft soft copy material, my understanding, and I'm sure I'll be corrected if I'm wrong, is that all the information was handed over in hard copy, and access to the portal or the software, because it was held under contract, and the contract was with my client, I think there has been a dispute as to the extent to which let us say that the access to the material is the claimant's property, and the ability to access is the defendant's property in respect of being the one operating the software system. The analogy might not be strictly correct, but as I perhaps if I could, as I understand it, and I won't claim expertise in this, sir, but it is positioned as if, in respect to the bank account, bank statements were handed over, but electronic access for which was held by a customer was not provided.
Well, but Ms. Montalbano told me that the electronic access could be, as it were, switched over if the defendant provided a suitable letter. I think the reference was I forget what the
no
name was.
objection letter.
No objection letter, and that wasn't provided. Is that so?
No, sir, it wasn't provided. But
yeah, but
sir,
was that a means by which access could have been provided?
Well,
Do you agree with that?
I understand that the information had already been handed over at that point.
That's not the point, because presumably it would be of value to the claimant to have access to the database, even though it had hard copy material. So back to the question, are you able to agree that access to the database could have been, in quotes, switched over from your client to a STIC, I think it was, wasn't it, by a letter of no objection?
So my understanding is that the information that was being held pursuant to a contract with my client.
It doesn't answer my question. You may not be able to agree.
No, I'm not in a position to take that any further.
Right. Well, we're starting to get into a slightly more tricky territory if we can't have agreement on what occurred. And I'm sure neither side wants me to have to decide the original dispute. Right, you did say that there were some other considerations. Would you like to indicate what they were?
In respect of, as I indicated, just touched on just a moment ago, the dispute has effectively been resolved pursuant to the orders of the registrar. That wasn't a legal determination, my submission, it was an administrative act, and but it made almost everything that has occurred in these proceedings moot, and it, as my friend indicated, and it has, of course, those orders also dealt with a far greater range of issues than the specific issues before the court today. My submission is that, well, I make two submissions in respect of costs, if I may, Your Honour. One is a procedural consideration in that if a claimant is claiming costs, it is required to provide a statement of costs before the hearing, and I'm not aware of one having been provided.
I think that I may be wrong, that may only be for applications, but...
No, so my understanding from 3830 is that all cases which are to be less than a day. Sorry, I have a copy here.
Right, I've got it.
30 days, which one?
3830. In my submission, this is a case in which there should be an immediate assessment of costs, and
right. So that's no reason not to decide which way the cost should go, though, is it?
well, sir, it is a consideration to take into account in making any cost orders. And
why?
Well, sir, because no statement's been provided, in my submission number 3837, a failure to provide a statement of costs will be taken into account by the court deciding what order to make about the costs of the claim.
Yes, I'm reading it, but you may be right, so we'll see.
But sir, turning to a more substantive, because I appreciate that that's a consideration. In my submission, I've done some looking on the subject, the question of how to exercise the discretion in respect of costs when, let us say, neither party has been successful, and that's certainly, and so drawing a distinction between on the basis that costs follow the event. Perhaps the question is, has there been an event in this case for costs to follow? Now, in my submission, there is no event for costs to follow because everything has happened pursuant to the registrar's order.
Well, no, the normal event is the order disposing of the proceedings. We haven't actually got to that, but in some manner, proceedings will have to be disposed of, presumably by an order dismissing them because they no longer have point. But that, and while that may be the event, in the current circumstances, it's not necessarily the governing event.
No, sir.
And almost certainly not the governing event.
But if I may take my submission one step further, the rules, of course, draw a distinction between those cases in which there's been a capitulation by discontinuance or an admission, and those cases where the proceedings have effectively become pointless. And in my submission, that's where we have reached today. Now, I wasn't able to find anything in respect of the under the English, under the CPR. I'm sure it's there, but I simply was not able to find anything. I have, if I may, sir, I have though found authority from the High Court of Australia, decision of Mr. Justice McHugh, or Justice McHugh, I should say.
I'm delighted to hear that because I remember that case last week and I couldn't find it.
I'm sorry, I missed you.
I'm delighted you've done it because I knew there was that case and I was looking for it this morning but couldn't find it.
Sir, Minister of Immigration and Ethnic Affairs, ex parte Lai Quinn. Is it?
That rings a bell. Have
yes.
you provided a copy of this one?
No, not yet.
Right.
Just
my recollection is it's quite short.
It is, and perhaps I apologise, sir. It's not an official copy, but
That's all right. There are in fact some cases in England that are referred to in the White Book, which I have not looked at. I just know they are there.
yes, sir. I'm sorry. I simply wasn't able to access that information. But if I think the discussion is at the bottom of page 2 and the first couple of paragraphs on page 3.
I've read down towards the bottom of page 3.
Yes, sir. And I think I appreciate the rules will of course be different, but that seems to me to be, if I may respectfully say so, a very sound description of the way the discretion should be, any cost discretion should be exercised. And the question then becomes whether the parties have acted reasonably in commencing and defending the proceedings, unless it is apparent that one party was almost certain to succeed in the litigation. Now, in my submission, I don't think there's enough before the court to be able to make a determination as to whether one party would have succeeded or not. And in my further submission, because the proceedings were rendered futile by the intervention of the registrar's order, and that order was then, steps were then taken pursuant to that order. In my submission, it's the defendant can't be characterised as having behaved unreasonably in respect of its conduct of the proceedings.
Why is it not correct for me to take it that the order made by the registrar was a correct reflection of the position between the parties? Therefore, the defendant was unreasonable in not providing the material until forced to do so by an order of the registrar, which happened to be made before any order of the court.
Because the registrar, in my submission, that is possible, but the registrar was exercising an administrative power under the Strata Titles Law, resolving a far greater range of disputes in respect of the index building, this manager, and various other parties.
Why does that matter, though, if you resolve this dispute, albeit you might say administratively, but no doubt administratively he was acting according to law?
The reason I would say that, sir, is because I will find it in a moment, but we come back to the problem that there is a latent tension in the way that the schemes for the building were created. In theory, and I'm just finding in the Strata Title Law, So I'm just, and I think it's in the authorities bundle under Article 57.
Which bundle am I looking at?
Oh, sorry, the skeleton authorities bundle of the claimant.
That I have the authorities bundle here for some reason.
It's called Skeleton Arguments and Authorities.
Oh, I beg your pardon.
Yes, and it's tab 2, Article 57, page 34.
No, I've got the claimant skeleton argument. Is that the one I should have?
Yes, yes.
Right, okay, thank you.
And under tab 2,
Tab 2, yes.
the IFC Strata Law, page 34,
Yep.
Article 57.
Mm-hmm.
What this provides is that under the Strata Title Law, different bodies corporate can exist in respect of one strata title scheme.
Yes.
However, under Article 57.7, as you would expect, it says the constituent documents must define the functions, responsibilities of each body corporate, must provide for a resolution of disputes, must ensure the powers of the body corporate, insofar as they relate to a lot within the scheme, are directly exercisable in relation to each lot by one and only one body. The problem that appears to have arisen in this case is that both the principal body corporate and the three individual subsidiary body corporates had rights in respect of the appointment of a manager.
Well, what can I ask? We might be getting into the merits here.
Yes, sir.
So I don't want to get into them too far, but let me just test with you a possibility. There was a contract between the claimant and the defendant. That contract said at its end the defendant would give things to the claimant. The contract came to an end. The defendant essentially says, as I read the materials that I've read so far, I didn't give the materials to the claimant because I say I was appointed by the overall body corporate as manager. Now that puts it maybe a little too highly because it really was saying that if something had happened I would have been appointed. It does occur to me, why is that an answer to the obligation to hand materials over? Because it was still obliged to the claimant to hand the materials over, even if the result was, or the practical matter was, that the claimant had then to give the materials back.
I think an answer to that, sir, that the contract has to be, in my submission, has to be read subject to the parties' obligations under the scheme. And if my, I appreciate it's difficult to do this without getting too far into the merits of the dispute, but any obligations that the parties had under the contract sat alongside obligations that the parties had in respect of third parties, namely the principal body corporate, under the strata management scheme. And I think also
But why? There were contractual obligations between claimant and defendant. The claimant may have been under some kind of obligations vis-a-vis the overall body corporate, but that was nothing to do with the defendant. At an extreme level, the claimant was entitled to say, I don't care that I'm breaching my obligations towards the overall body corporate. I want my material. Give it to me. Wasn't it?
Perhaps, sir, if I can take it both one step forward and one step back, and coming back to the point that why the registrar's actions can't necessarily be taken to be simply a reflection of the legal position as between claimant and defendant. In my submission, the registrar in his actions was trying to resolve I've described them as latent tensions that had been allowed to be introduced into the scheme by virtue of the way the scheme was drafted and registered. I also, and all of the parties' rights in my submission, both claimant, defendant, any third parties, are subject to their obligations under strata title law. If, just to take an example, and the registrar, let us say in parallel, as I understand it, was one of the issues during the course of this dispute, maintains a register of who is to be, or who is the manager of a property, and I also understand it, that the way there is a supervisory role for the registrar in maintaining that registration. To say that in my submission that's an example of a case in which it is not simply that the contract has expired and you have to hand back the property does not reflect the position that the parties have by virtue of their relationships created by the strata title law and its administrative regime. And that's, in my submission, why it's not simply enough to say the contract has ended, that's all we have to worry about, give me back the property.
Well, if I were to have to go into the real merits of the case, I must say that that's not a proposition that I would lean towards. Let's put it that way.
Well, I can make the submission, sir, and leave it at that. But
I wonder if this might be a suitable course. You may have gained an impression. I don't know if you have. I think I might just take an adjournment for 10 minutes. And you might see about the letter and also see about whether there's some bit of further negotiation between the two of you over costs can be fruitful.
thank you, sir.
All right.
Another chat.
Sorry, just think about how important you give their but then we've got to do it on oath. Right, so what you want is an affidavit. That's it. I think we're speaking about certification. No, as I said, I don't think we can say this will be certification, but no, it's a certification. Yeah. Yeah. So, yeah, that doesn't make it under penalty of perjury. Right. Yeah, if that's a wrongful statement, what are the penalties that flow from that? Yeah, 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 yeah. Right, gotcha. Okay, thank you. All you're wanting, as I understand, you're wanting a certification that outright says, whatever, subject to instruction, whatever it is they're ordering. Obviously, if that is not the case, you can rely on that in taking whatever further steps you need to take. I mean, that's how I would see what it is, but it does not contain, and I don't think this court has jurisdiction to make those that go beyond that. Yeah, that's assuming there's more. I thought it was talking about certification. I agree your analysis is correct if there were an order and failure to perform the order leads to consequences. But as I said, no, the consequences say you would come back and say, we want a certification. We sorry, yeah, I think, but I think whatever you do, you have to stand ready to take further steps. I think it's the limit as to this court, if we give the certification and as suggested we used to have your liberty for further application, so you wouldn't need to go outside these proceedings. I'm getting some instructions on how we deal with this proceeding. Costs would be if there were liberty to bring matters back on this one, I think if there were outstanding issues, that's how they would be dealt with. But as I say, I think no matter what happens, that's going one step beyond. You getting an order.
Well, so you wouldn't be opposed to
No, I need some instructions as to what happens, but I think the judge indicated that the certification should be enough for him to dispose of the application without him having to make any orders or findings in respect of. Well, I think I thought we were talking about the same thing earlier, to speak with cross purposes. I will discuss that with get some instructions, but I think that we'd probably say we can certify we can do this, but Can I just check? This is the wording. This is your wording. And that is what you're looking for, irrespective of
Yes.
the format in which it's delivered.
Yes.
That's the wording you're
Yeah.
looking for.
Yeah. That's part of the
Right, okay, that's what you're seeking.
yeah.
Yeah. Yeah.
All rise.
Or perhaps I repeat the word with which I began the morning. Where are we at?
Yes, Your Honour, I had an opportunity to discuss with Mr. Gambriel. With respect to the certification, we were seeking a certification as part of an order issued by the court, because in the event the certification was incorrect, there was the threat of contempt of court on the defendant. But it became clear during the discussion that without an order of the court, the defendant is not willing to provide a certification under oath or an affidavit. So unless an order is issued by the court, we do not accept the certification.
Well, the court will not make an order in the terms that there should be a certification. The court would make an order that all materials be handed over, but it would only do so if there is evidence that some materials may not have been handed over.
Yes, Your Honour. We are not in a position to tell the defendant if certain material has not been handed over, or if they are retaining copies of documentation which is the property of the body corporate. That's why we were seeking them to certify that they're not retaining any documentation or any data which is the property of the body corporate.
Well, you don't know.
Exactly, we do know, and we're
Well,
not in a
unless you can
position
show
to know.
that they do have material that's yours, apart from the stuff that's already been handed over, I think you have some difficulties.
Well, if the court orders the defendant that to the extent the defendant still retains documentation which belongs to the body corporate, such documentation will have to be handed over, it's going to be the defendant that has to comply with the order.
No. not make an order in those terms unless there was reason to believe that there was still some material they held. I do find this quite silly, if I may say so, as a commercial matter. If the defendant's position is that they do not have anything, why not certify? Why not put on an affidavit saying that?
Well,
That may provide a suitable sanction, because then if the affidavit's false, someone gets thrown into jail for perjury.
Sorry, Your Honor, we believe that the defendant's behaviour during these past months demonstrated that an affidavit or a statement under oath would be necessary in this case.
Well, that really doesn't deal with what I said, but I do find this quite silly. Is there some way you can assist to cut this Gordian knot?
Well, yes, sir. I do wonder actually if, with respect, I'm not avoiding the issue, but I wonder if the position has actually been addressed. We have, if I refer, Your Honour, to the second witness statement of Jennifer Blackwell, which I trust it was filed in response to the further witness
in
statement.
response to the desire to put further evidence in.
Yes, sir.
Yes, I think I have that one.
Yes, sir. And if I can refer you to in the exhibit on page 8,
Yes.
there is a letter from the defendant's lawyers, and if I can refer you to Order 1, the very bottom of the page, notwithstanding the absence of court order in compliance with the interim orders, Associa provided all of the body corporate property in its possession in physical and electronic format to Associa, which was available and sets out when various documents were collected and likewise. Furthermore, the witness statement itself, right at its conclusion, says any statement made on behalf of Associa in those letters represents Associa's position in respect of the matter stated. In my submission, sir, it's this, so to speak, the certification is already there.
It really is a situation where I think the claimant would need to show that there is something, or maybe something at the very least, that has not been handed over. But the futility of this is evidenced by the fact you are unable to say that there is anything.
Yes, Your Honor, I understand.
It really is quite futile, isn't it? If there were, I'm sorry, my apologies. If there were reason to think there was something else, you or your new manager would know. It would say, "Oh, wait a minute, we should have been given this or that, but you haven't." But nothing of that kind is being said.
Yes, Your Honor. The witness statement provided by the defendant does not state that they don't retain any documentation. It contains a cross-reference to the letters from the solicitors to the claimant solicitor. So, if I may suggest, if the defendants can provide an affidavit simply stating that the defendant does not retain any documentation belonging to the body corporate, this would be sufficient for the claimant.
Well, that would be equally a practical solution to a silly situation. It would be equivalent to the certification that was talked about earlier, Mr. Gamble. Is that something that can be done? Can Ms. Blackwell do an affidavit saying that the defendant does not have any of the material referred to in the order that is sought?
Well, sir, I think my submission would be that if we are trying to dispose of matters today, I would have thought that what we have there is sufficient.
It's not as direct as the affidavit. I'm trying to achieve a practical situation to what should already be fairly plain. I regard as a pretty silly situation.
Your Honour, if I may.
No, I'm speaking to Mr. Gamble.
So,
I appreciate the position. I think, well, obviously it would be a matter for further instructions. I'm sorry, I can't take that further at this point.
Can they be got quite quickly?
Yes, sir, I think reasonably quickly. I can take some instructions.
All right. Well, let's just move on then to tell me what this position is about costs. Back to you, Ms. Montalbano.
yes, Your Honour. The parties are very far apart, so no settlement can be reached on cost.
All right.
Our position, again, as previously stated, is that the cost should be awarded to the claimant. Mr. Gamble provided a copy of the case he was relying on, and on page 3, middle of the page, it states, if it appears that both parties have acted reasonably in commencing and defending the proceedings and the conduct of the parties continued to be reasonable until the litigation was settled or its further prosecution became futile, the proper exercise of cost discretion would usually mean that the court will make no order as to the cost of the proceeding. This is precisely the issue here. We believe that the defendant did not act reasonably, and therefore the claimant should be awarded cost. Mr. Gamble insisted several times that the defendant complied after the order of the registrar. While it is true that the defendant started to hand over documentation after the 4 of December 2015 order, the Register of Real Property had previously ordered on October 27 and confirmed its order on November 9 that Associa was the new body corporate manager, and therefore the defendant should facilitate the handover of the body corporate property to Associa. We believe that this shows that the defendant has acted unreasonably, and also the fact that the defendant complied almost at the eve of the trial, we believe speaks for itself about whether they had a reasonable basis under the strata law. We believe that the fact that the defendant has indeed complied and handed over the document shows an acknowledgement from the defendant that it had to comply, and in fact it had violated its obligation under the management agreement.
Well, we seem to be getting towards common ground, at least to this extent, that the question to decide whether there should be an order for costs in your favour or an order that each party pay its own, in the present circumstances, is whether the defendant acted reasonably in defending and continuing to defend the claim.
Yes, Your Honour.
Is it possible then to resolve that by each of you taking me to such material as is before me, which you say bears upon that, which in fairly short form?
Yes.
So you tell me what you say, why you say they are unreasonable by pointing to such little bits of the material that there are, and then Mr. Gamble can do the same, but for the opposite contention, and that will let me resolve the question of costs between you. Is that a sensible way of doing it?
Yes, Your Honour.
Do you think so, Mr. Gamble? For example, that letter I've just been referred to provides me with a brief history of when materials were handed over. That's one thing that I can take on board as, in effect, showing what Ms. Montalbano has already told me from the bar table. Are you both happy that we deal with it that way?
Yes, Your Honour.
Yes, sir.
All right. Well, Ms. Montalbano, you tell me then why, that is, the facts which you say mean that the defendant did not act reasonably in defending the proceedings or continuing to defend the proceedings. Now, there may be a distinction between the two of them.
Yes, Your Honour. Bundle B, Volume 2, page 0547. These are the minutes of this special general meeting of the retail body corporate. On page 0550,
I beg your pardon, I'm just still catching up. I
Yes.
found the minutes at page 547. Yes.
0547, and if you can go to 0550,
Yes.
it shows that it was resolved by ordinary resolution that the Staco property manager is and be appointed body corporate manager of the Index Tower Retail Body Corporate commencing from 15 June 2015.
Yes.
On 7 June 2015, Bundle B, Volume 2, 0555, the former chairman, Mr. Anderson, of the Retail Body Corporate, wrote to the defendant and asked the defendant to return the body corporate property to the claimant. Towards the end of the page, the last paragraph, Associa is hereby directed to cooperate immediately with the Staco and the Retail Body Corporate with respect to handing over its function as manager to a Staco on or before 15 June 2015. Further letters were sent on 1st September 2015, 1st October 2015, and a legal notice on the 2nd of October 2015. The references in the bundles are at pages 0644, It's the
It might be enough to just go to the last one where it escalated to legality, might it?
yes.
What's that one?
It's a 0677. It's a legal notice from my law firm to Associa, and the last paragraph, should Associa fail on page 0678, should Associa fail to return the body corporate property by the deadline set out in the email of the Secretary of the Retail Body Corporate, and or should Associa fail to issue a retraction of the notice of annual general meeting by the same deadline, we are instructed to initiate legal proceedings against Associa without further warning. Legal proceedings were in fact commenced
Well, just before you get to that, might it be useful if there were replies from the defendant to these various demands, in particular that last demand, for me to see what they said in reply to justify their position?
Yes.
Can you refer me to them? Is it maybe good enough if there was a comprehensive reply to the solicitors, to the lawyer's letter, to show me what that reply said?
I apologize, Your Honor. I don't see on the record a response to our letter dated October 2nd.
Right. Well, do I take it there wasn't a response, or might there be one, but it just hasn't made its way into the bundle? Can you help, Mr. Gamble?
So I'm not certain if there was a response, but I wonder if the difficulty is that the letter, if I understand correctly, is dated 1 October.
2 October.
2 October. And if we look at the particulars of claim on page 6, we see claimant requested defendant to comply with its request by noon on Sunday 4 October. It could well have been that the letter itself was sent on Thursday, and particularly given I think proceedings were filed on, it might have been the 5th or the 6th of October, there just were not sufficient working days in there for anyone to reply to it, and all of a sudden there were proceedings served. So
well, that may be the case. Anyway.
Yes, Your Honor. With respect to this point, there was the body corporate started drafting letter on June 7, so this was not the first notice. There was another letter on October 1st, an email, sorry, on October 1st, 0675, from the Secretary of the Retail Body Corporate to Ms. Blackwell, giving the same deadline of Sunday for October 2015. You are directed as follows: return the common seal of the body corporate, return and provide to myself as secretary data records, keys, bank accounts, stamps and other property, effect the transfer to myself, access all electronic system used by the body corporate, including my strata and my community portals.
Yes, well that doesn't help on the question of any reply. Anyway, there may or may not have been one. Quite possibly it wasn't one, but whatever happened, I can't be shown.
Yes. So.
Good. Now please continue.
Yes, so the claimant filed this case on October 6, 2015, seeking specific performance. After that, an order of the first order of the Register of Real Properties was issued on 27 October 2015, and the reference in the bundle is a bundle B, volume 2, page 0707.
Give me that reference again, please.
Yes, page 0707.
Ah.
It's an email from Mr. Jaber Al-Suwaidi, dated 27 October 2015.
Let me read that more carefully, would you?
Yeah, the order dealt with the various components of the building, but with respect to the retail component, the registrar confirmed that the Asteco was the new appointed manager for the retail body corporate. It's dispute at retail component level, the fourth paragraph further down. On 1st June 2015, an extraordinary general meeting, the retail unit owners resolved for the appointment of Asteco as body corporate manager for the retail component. A body corporate manager agreement for the retail component was signed with Asteco effective as from 1st September 2015. The Register of Real Property, therefore, sees no objection to issuing a certificate to the retail body corporate with Asteco as its body corporate manager with effect as from 1st September 2015. The page 0708, the retail body corporate through Asteco shall liaise with Associa regarding the handing over of data relating to the management of the retail component. Any personal data shall only be handed over to Asteco as licensed body corporate manager. Also, Your Honor, the previous page, 0707, the Mr. Al-Suwaidi stated that under Section 65 of the DIFC Strata Title Law, each body corporate has the right to appoint its own body corporate manager. And this is relevant because this goes to the defendant's point that it was necessary for the principal body corporate to approve the appointment of the managers also for the other components of the building.
Well, now, it would help if you could tell me just what the effect of this letter from the registrar is. In other words, does the strata title law give the registrar power to settle a dispute by making a binding ruling of some kind? And was this such a thing?
Yes, Your Honor. Yes, the registrar indeed has jurisdiction under Part 8, Article 98, it's the binder, claimants, skeleton arguments, and authorities.
The article again, please. 98, did you say?
Yes, sorry. It's claimant, skeleton argument, and authorities. Tab 2.
I have the law.
The strata title law, page 57.
Yeah.
It's part 8 of the strata law, article 98.
But was this email that you've taken to me
Yes, Your Honor. This,
on an application for relief, and what was the application?
the application, I understand that there were meetings with the registrar and the parties, and after these discussions and meetings, the registrar issues an email order.
If I'm going to really understand this, I would need to know a bit more than that, including whether or not the defendant was in some manner a party to the application for relief. See the email is sent to the defendant. And it talks about an index letter to the registrar.
Yes, there is a letter on page 0704 from the Index Tower Bodies Corporate on 25th October 2015. And there is an email 0702 from Miss Jennifer Blackwell Spencer to the registrar on 22nd October 2015.
What does the index letter say about the relevant matter? It looks as if it might be on the second page, at about point 2 on the page, failure by Associa. Should I understand that to be the index letter which provoked the email at page 707?
Yes, Your Honor. I understand that there was a meeting with the registrar also on the 25th of October, and after that meeting, the registrar issued his email order on 27 October 2015.
Okay.
And the defendant asked for clarification whether this email was indeed an order under the strata law, and such clarification was provided by the registrar on the 9th of November, page 0721. Dear Jennifer, we refer to our email dated 27 October 2015 and your letters dated 4 and 8 November 2015. Kindly treat our email dated 27 October 2015 as an order issued by the Register of Real Properties pursuant to Article 98 of the Strata Title Law for Associa's non-compliance with Article 69 and 65 of the Strata Title Law as detailed in our above-mentioned email.
So just hang on a minute. 60.9 is about holding the meeting. 65 is about appointment of a manager. Yes, all right.
Yes.
So where to from there?
Yes, so the Register of Real Property confirmed that the 27 October email was an order, and in fact immediately after the order of 27 October, the Register had issued a certificate of establishment showing that Associa was the body corporate manager, the new body corporate manager for the retail component. It's on page 0712.
Yeah. Yes.
Yes, the defendant still did not comply and didn't hand over any documentation to Associa, despite an order and a confirmation of the order of the registrar. On 4 December 2015, the registrar issued another order, which is the order Mr. Gambriel was referring to previously, and that order is in the claimant's application bundle dated 8 February 2016. Tab 4. The order starts on page 001 of tab 4. If Your Honor turns to page 009, in relation to the office retail body corporate, Associa is hereby ordered to allow Associa unfettered access to the building by no later than 11 a.m. on Sunday, 6 December, and to hand over all keys and other means of access it has relating to the office retail body corporate to Associa. Associa is hereby ordered no later than 11 a.m. on Sunday, 6 December 2015, to hand over to Associa all documents and information as described at paragraph 14b above, pertaining to the office and retail body corporate. We believe your Associa, the defendant, started complying after there's a third order of the Register of Real Property and handing over documentation.
This order, you mean? After
This
order?
one, yes,
Yeah.
Your Honour.
Just remind me where that letter is, which conveniently sets out, assuming you agree with what it, how it says it happened, what was handed over. That was in.
Yes, that's in Miss Blackwell's witness statement. It's in the new binder provided by Mr. Bramwell this morning, and it's tab 5. Yes, Your Honour. So Associa started to comply after the 4 December order. It provided documentation in mid-December, in late December, and in mid-January. But as we previously discussed this morning, it refused to provide access to the primary data to the principal, to the new manager, to Asteco. So it is true that Associa has now complied, but Associa has complied after months since Asteco was appointed manager, and after a lot of resistance and the need for the claimant to commence this action, and after almost 3 orders of the Register of Real Property. And we submit that the defendant has complied only at the eve of this hearing to avoid costs.
Okay. All right. So now, what you say is that they were unreasonable in not complying sooner with the registrar, with what the registrar told them to do, and the fact that they eventually got around to doing what they were told to do shows that they unreasonably resisted the request through these proceedings to do it.
Your Honour,
That's the essence of what you
yes,
say.
precisely, yes.
Right. Do you want to amplify that, or is that good enough for me to understand your position?
Yeah, yes. I mean, even before the registered orders, they were requested several times. They had an opportunity to comply. They received various letters from the body corporate. They were informed that the resolution had been passed. That was in June. We're now in February. This issue has been resolved with respect to the Maestrata, which was the only outstanding issue after handing over hard copies of the documents. It's several months.
All right. Okay. Well, I'll now hear what Mr. Gamble says. That's all not unreasonable.
Thank you.
Thank you, sir. I think, if I may, subject to anything you want to say, I'd like to start, given that, as I understand, the essential proposition that compliance with the registrar's order is given effect to the what the claimant is seeking from these proceedings, and that it was unreasonable for the defendant not to comply with the registrar's orders as they're described sooner.
Can I just interrupt for a second? At some point I would like to be taken to whatever material is before me, and let me make it plain, I'm going to act upon only what I'm taken to. I'm not going to rove for myself through the material. To any response from the defendant to the various demands in which it explained why it wasn't going to do what was asked of it.
Yes, sir. That,
at some point, take me to whatever you can.
that's not in the material for you. There is a response, but it's not in the material for you.
If there is a response and it's available, and with Ms. Montalbano's agreement, maybe it should be shown to me so I can at least see both sides of the story. It may or may not be in your favour. As I may say, that's a stupid response.
I'm just asking for that response to be printed. I understand, and I'll stand to be corrected, but if we go through the sequence of events, if we take it from the demands of 1st and 2nd of October, I understand the response was on the 4th or 5th of October. Proceedings were filed on the 5th of October. And I think, with the greatest respect, particularly given the nature of the claim, once the taking the immediate steps in response to the proceedings, and subject, of course, to the basis upon that, whatever that response to it was. But given the way time limits work, I would submit that simply taking the immediate steps in response to the claim in itself can't be characterised as an unreasonable step, just in respect of that period. I appreciate that.
True, but I do know that the defendant manfully resisted for quite a while in the proceedings, because I've got loads of witness statements, not loads, I have some witness statements and skilled arguments and so on. So,
well, with respect, sir, I'm not certain it can be characterised as manfully resisting for in the proceedings, because the last document filed was the 21st of October. The defendant was served. It had 14 days to file a notice of appearance in a witness statement. It did that. And then, apart from the further evidence in reply from the claimant, I think it would be fair to say nothing happened in these proceedings.
yeah, no, well, you may be right. I may have overstated it, but I did mean that I was aware that the witness statement opposing had been filed.
Yes.
So then let's bring it down to that.
Yes, sir. And if I may say so, in addition to any substantive defence, part of what was being sought in these proceedings, in my submission, went further than being simply between the claimant and the defendant. Now, as it turned out, many of those other issues fell to one side. But just as an example, seeking a declaration as to the validity of an appointment of a manager, in my submission, that would be something that should ultimately require either the consent or the appearance or joining of the principal body corporate. Otherwise, the declaration is of minimal effect. Now, that is something that could potentially have occurred, but again, I think we come back to the point that the immediate steps were taken, and then, because there was a broader range of battles going on after that, in many respects this sat and nothing happened with it until we got to the last few days, during which time the various steps have been taken which have rendered these proceedings in my submission futile. But sir, if we then move to the email of the registrar's email of the 27th of October, now it's always been Associa's position, and sir, page 707 of the bundle 2. It has always been Associa's position, and if I can do no better than refer you to page 715, which was Associa's response to it, that the email from the registrar did not comply with what was required for it to be an order for the purposes of Article 98. Am I correct? Of the strata title law. My submission that the registrar is expressing a view on certain points, but
Yeah.
So, in the 4th of November, the Associa responded, and say we don't consider does not appear to constitute an order or orders pursuant to the requirements of Part 8 of the Strata Title Law. And the response is the email on page 721.
Yeah, the registrar said yes, it was an order.
Says it was an order.
Yep.
Now, with respect, simply saying so doesn't make it one, if there are other requirements that need to be satisfied in respect of it. And if I may also refer you to what the registrar says slightly further down, regarding any appeal of the registrar's decisions, kindly note, though relevant fees have been prescribed under the regulations for referral to the Strata Title Board, the same has not been constituted. There's no Strata Title Board, you may directly appeal against the registrar's decision to the DIFC courts. Again, that's not what the legislation provides. And with the greatest respect, I think that at the very best, the status of whatever the registrar was doing at that stage was unclear. However, I think we do accept that when we turn to the registrar's order of 4th December, while we might or might not agree with it, that is on its face an order under the Strata Title Law, and Associa started to comply with it. Now, while there were some delays in that compliance, those were occasioned by there was some dispute as to who had advised who as to where material was to be picked up, and that
I think that becomes fairly minor
exactly, sir.
in the present scheme of things.
Exactly, sir. But the point is that having received the order of the 4th of December, which was on Friday, as it transpires, if the 6th was the Sunday, when the order was meant to be complied with, Associa complied with it. And I think that I don't think Associa can be characterised as having been non-compliant for a period from 27 October through until the 4th of December. The other point I would make, sir, in relation to the order of 27 October, there is provision, of course, to appeal. The time period for an appeal is 30 days. That's provided appeal to something called the Strata Title Board, which has not been constituted, it appears. There's a 30-day period to appeal, and as I understand it, no order is enforceable under Article 123.2 until the time for commencing an appeal has expired. So I think that Associa, there was not a requirement for immediate compliance in any event, but as I said, I think the status of whatever happened on the 27th of October is unclear at best, and to characterise Associa as having been unreasonable for not doing what it was told to do in that email, which, if I may say, when reading it, it appears to be no more, in my submission, than a view as to what needs to happen to resolve matters. It does not take the form of that 4th December order, which is clear as to what the parties are expected to do as a consequence.
So, what? Okay. Well, first of all, are you able to find that letter?
Yes, sir. I have that. 5th of October.
Ms. Montalbano, can I have a look at it while you look at it, and you tell me then whether I can pay regard to it? If you object, I'll ignore it, but this will save time. objection to
No,
my
Your
taking
Honour.
this on board?
No, we don't object.
Yeah. From my reading of the witness statement of Miss Blackwell, which was not a detailed reading, I make that plain, I just wanted to familiarise myself. It seems that that was really a greater explanation of what is put in essence in this letter.
Yes, sir.
Would that be a correct view of it?
Yes, sir. I think that's a fair description of that.
All right. Yes, thank you. So,
So,
well, there's an amount to this. Unless I decide the main dispute, in other words, whether this letter is correct in providing a defence, the defendant can't be said to have acted unreasonably in putting on the defence, or not responding immediately to the registrar's first letter, because that was obscure and did not really resolve matters. But when the registrar's December 4 December communication came, that actually concluded matters, albeit adversely to the defendant's position in the proceedings, and it acted reasonably thereafter in complying.
yes, sir. That's
the essence.
That's
of
the
what
essence of the submission.
Yeah. All right. I think I follow that.
Sir, is there anything further?
Don't think so. No. What was on top? That's his position.
Thank you, Your Honour. I just want to make one last point. The registered orders are just further confirmation that the defendant had an obligation to hand over. The real date that we should be focusing on is June, when the contract was expired, with the contract with Associa expired. Under the contract, it's clause 6.25.
But just hang on a minute. I think I anticipate what you're going to say, but the problem is that if I'm going to say the real unreasonableness was not immediately handing materials over in June, then that would require me to essentially decide the main case, would it not?
I believe, Your Honour, that the unreasonableness is shown by the months of delay in complying with the obligation. When the contract expired in June,
I'm sorry, please continue.
yes, when it was the defendant was requested several times, when there were orders in October, a confirmation in November, a further order in December, and when the issue was basically resolved, I understand last Thursday, when the primary data were finally transferred to a STACO. So if we see all these events together, it's a delay of several months, and all of this could have been avoided if the defendant had not resisted to comply with its obligations.
Well, that may be right, but it's only right if I were to say that the defendant was unreasonable in putting forward the reasons which he put forward in this letter and then in the proceedings for saying that it was not obliged to hand over the materials. In other words, if I were to decide that the defendant was wrong in its legal stance. So if you want to put that submission, you're thrusting me back into having to decide on the merits. I think you are. And where am I wrong in that?
Yeah, this is
Yeah. So what do I do? The English case law, which I mentioned was in the white book, which I forgot to bring in, says that the court should be very reluctant to decide the merits of the case just in order to decide where costs should fall. That the context is where the case has been settled, and I think that's a fairly accurate summary of what the cases referred to say. I have not gone to the cases themselves, so there's a large extract from a judgment of Sir John Chadwick, as it happens, set out in the White Book. The approach in the Australian case is certainly consistent with that, and perhaps a little stronger on not going into the merits. And it does occur to me that it would not be consistent with the overriding objective and the court's obligation to be efficient and so on, to decide a dispute unnecessarily when the occasion for it has disappeared. So I would be extremely reluctant to go into the merits.
Yes, Your Honour, I understand. I believe that the fact that the defendant has finally complied is a huge factor that needs to be taken into consideration, because it appears that the defendant has acknowledged that it indeed had an obligation to hand over the corporate property, and the defendant also acknowledged that Associa is the new manager and that the data and information are the property of the body corporate.
That would be right if it was simply a case that the claimant brought the proceedings, the defendant put on a defence saying no, I don't have to, and then a couple of months later the defendant handed the material over. One could then say, well, that shows that they were acting unreasonably in initially saying they didn't have to hand it over. Here we've got the added factor, however, of the registrar's order. What Mr. Gamble is really saying, I think, is unless I decide the merits, I can't say that the defendant was acting unreasonably up until the time the registrar gave a clear and binding order. The defendant complied with that order, and his compliance with that order therefore cannot be taken as any kind of admission that he was wrong in the beginning.
Yes.
What you can say is that the fact the registrar made the order shows that that was the right course, and that's what I was talking to Mr. Gamble about.
Yes, Your Honour.
Today.
Yes, Your Honour, and also the registrar made a previous order on October 27, and he confirmed that such email order was in fact an order, but the defendant still waited until the 4th of December order to start complying. So at least this is it's more than a month and a half after the first order of the registrar.
Okay, I follow that.
Yes, I mean, Your Honour, we believe that all these events and all these facts shows that the defendant was unreasonable in resisting and really started to hand over the documentation because the hearing was scheduled, and after the order of the issue at the beginning of December. I mean, we believe that all of this could have been avoided if the defendant had complied previously. I mean, clearly the claimant incurred cost in introducing the we received for the first time the letter from a bank saying that the defendant was ready to provide an NOC and hand over an archive copy of the Maestrata data only, I believe it was on February 15. So even if it started to hand over documentation in December, there was still this issue outstanding. I mean, Your Honor, we believe that all this fact shows unreasonableness on the part of the defendant.
Yes, all right. Well, thank you very much.
Thank you.
What I think I will do is I will not give a decision immediately. I'll give it at 2 o'clock, because what I would like to happen in the meantime is to see if an affidavit from English Blackboard can be obtained, and see if that side of things can, as a practical matter, be resolved.
Thank you.
I certainly hope it can, because it really is quite silly to fuss about things. If the defendant says he's handed over the materials, Ms. Blackwood should be able to say an affidavit, and the claimant may not be entirely happy, but that's what it's got. So if I stand down till 2 o'clock, I'll give my decision and some brief reasons on the question of costs. Is that inconvenient for either of you? Is that all right?
It's fine for us. Thank you, Your Honor.
So see what you can do about that affidavit. Not only that, make sure it's done. 2 o'clock.
Thank you.
All rise.